Welcome back in. So we've talked about your spiritual walk. We've talked about powers of attorney. We've talked about advanced care plans. So in this series, what I'm talking about is estate planning, and it's really this mindset of estate planning for the rest of us, right? We're not talking about, particularly, everybody needs it, but so much of the estate planning world focuses on the high net worth individuals and all of that. And really what I want to do is I really want to help the average individual, the average family. So that's what we're talking about. So we've gone through some of the basics that I just recapped. My next one on the list is going to be wills. Reason why I'm talking about wills, remember I'm a Tennessee attorney, okay? Remember when it comes to estate planning and probate and that sort of thing, the redder the better when it comes to the states. But why do you need a will? Well, some people honestly don't. The intestate statutes are what they are. The courts understand them. They're not bad. They're the default setting. So in a situation where you've got husband and wife, they co-own everything, their properties with joint right of survivorship and all of that. Husband and wife have 2 children. Those children don't have any issues, don't have any concerns, don't fight, get along, all of that. When the first spouse passes away, typically the husband, if you don't know the statistic, it's 80% in old age, in older age, retirement age, your mature years, whatever you want to call them. 80% of men die married, 80% of women die widowed. Okay, so typically it's going to be the husband, right? So husband passes away, the land's owned by joint right of survivorship, means both names are on the title, which is the way it's supposed to be done whenever husbands and wives get married in Tennessee. So land passes by joint right of survivorship. They co-own the bank accounts. That passes by joint right of survivorship. They've got each other named in their IRAs, long-term care annuity, money market accounts, all that. So you've got all that set up. There's no need for probate in any of that. Okay, so the first one passes away. Now we've got the second one. Second one passes away again. There's no issues with the kids. Probate, intestate filing is really easy, and it just passes to the kids. Where there are issues is when you have blended situations, to where husband and wife have stepkids, where there's situations to where there's no kids, where there's situations to where we want to cut somebody out, where there's situations where we have trust issues with somebody. Is there a spouse that we're concerned about, or is there a special needs child that we need to deal with, or is there a special needs child or grandchild that we really want to fund? Is there a charity that we want to fund? All of that is where we really start to talk about wills and the desperate need for a will. Now understand that wills catch everything not caught by something else. So what could that something else be? Be a beneficiary form. I had a situation here recently where you had money that was held in trust. That trust then put it into an account that had a beneficiary form. Well, guess what? Didn't really matter what the wording was on the trust as to the distribution. It was that beneficiary form that controlled. So something may pass by beneficiary form. Okay, something may pass by account ownership. Maybe 2 people are on a bank account, and it's set up as a joint right of survivorship account. It doesn't matter, especially in Tennessee. It's a unique statute. To me, it's very specific that even if somebody tried to control that account by their will, it's ineffective. The account's going to control. So we've got beneficiary forms. We've got joint right of survivorship. Maybe we've got joint right of survivorship titled on land. So a lot of times things pass outside and probate's never needed, right? So when I've got those situations where I've got husband and wife with no issues, if they want to pay me, that's great. But I have some clients, I tell them, I'll be completely honest with you, I don't really have that big of a concern. I've had other clients walk in that, that late in life, divorced, all that sort of thing, and they had a will that gave things away to people that they hadn't seen in 20, 30 years and hadn't cared about them in even longer amount of time. Okay? So those wills go in a shredder. Those get revoked. So that's where I see the need for wills to come in. If it's a normal situation, husband and wife, no blended situation, that sort of thing, I'm happy to do them because, again, they bring peace, not chaos. But I'm not worked up about it if they don't have it, right? Because the intestate statutes in Tennessee are good. It's situations to where we've got blended, maybe even in later life we've got 2 single people living together. Well, what in the world's going to come of that? That's going to be a mess. They at least need a will. Okay? Now, a lot of times I get people coming in because they've seen all the advertisements that are people trying to practice law without licenses, especially investment groups, saying, do I need a will or a trust? Well, in that scenario, you always need a will. Will is the foundation. You don't build a house without the foundation. You always have a foundation. 2, 3, 4-story skyscrapers, they all have foundations. So you have a will as the foundation. Do you want extra control, or do you have situations where there are people or situations or needs where you have trust issues? If you have a trust issue, then you need to talk about a trust. Now, trusts are often oversold, and I'm going to talk about trust in my next one, but trusts are often oversold. Just because you're breathing in a red state, you don't necessarily need a trust. Now, if you're breathing and living in a blue state, that's a different conversation. Okay? There are things in blue states that we don't trust. Maybe it's the state laws regarding probate court. Maybe it's the estate tax, inheritance tax, that sort of thing. Whatever it is, trusts are about things we don't trust, but wills are foundational. So whenever you see the ad that says will or trust, which should I choose, understand that's not coming from a law firm or attorney. Okay, that's coming from people who are practicing outside of their license, outside of what's called their errors and omissions insurance, and they're just trying to bring in because they have other thoughts. It's about your money, or it's about something else, but it's not about whether or not you should have a will or a trust. Okay, so that's the episode for today. I think it went just a little bit longer than what I typically do. But I want to dispel a lot of the misconceptions about wills and really where they're needed, especially, again, when you're dealing with states like Tennessee, red states that have good, solid intestate law. I get people all the time say, well, I didn't have a will, so everything's just going to the state. No. There's no lawmaker that's worth their salt that's going to let a state do that. I've actually never seen assets go to the state. I've seen one that they may have gone to an estate, but I told them no, I didn't want to get mixed up in that. So that's the episode for today. I really appreciate your listening. Understand I am a Tennessee attorney practicing under my Tennessee law license. If you have not signed any kind of document contract with me, you've not paid me any money, don't expect to be one of my clients just because you listen to this, although I do appreciate you're listening to this. And if you would hit like and subscribe, I'm sure there will be more episodes in the future. Thanks again.